one thing I was thinking about. Billy Bunter isn't innocent in this, is he? In that, what do you say in terms of his own actions?
Your Honour,
That led to the incident?
We do not condone the things that Mr Bunter had to say in his article. However, we cannot possibly condone that he should be excluded on a permanent basis from the school for airing his own opinions. He can never give up his human rights.
What about the rights of Mr Canham not to be defamed?
I do accept that this should not occur, but perhaps Mr Canham could have dealt with young Mr Bunter in a different manner, such as this.
Specifically, Billy Bunter is a pupil. However, the headmaster is a professional and he should act in a professional capacity. Obviously, as a headmaster, he should accept that he is going to be criticised. And if he disagrees with the criticism, we are not disputing that he could have punished in the correct manner. However, what we are now arguing is that the headmaster has gone beyond that and Canham is against his human rights.
I just have one other question. The school itself, how is it held? Is it held as a company? Is it held as an independent person? How is the school actually held? How is the title held?
I believe, Your Honour, it is held as private company.
A private company?
Yeah.
And one other thing, other than the European law, was Mr Canham, did he have the right to cane Billy Bunter?
No, he did not.
In the laws of England and Wales in any event?
No, he does not. The law strictly states that obviously headmasters are not able to punish pupils in that manner, and it would be deemed as a criminal offence.
Was it an independent school?
It would, yes.
And what's your authority for that?
Got the authority?
Can you argue this one if you want? I don't know.
The Section 58 Children's Act 2004 covers the topic of chastisement with parents. However, it states the defence was abolished except in relation to common assault and battery, and obviously the caning would constitute battery.
Thank you.
Lordships, my name is Mr Buckley and I represent St Basham, so respondent in this case. To my left is Miss Pescott, my learner junior. Please your Lordships, I'll deal in the first submission in our case, which is that St Basham's is not a public body in the context of the Human Rights Act and thus has no obligations to follow the conditions of the Act. My Lords, may I draw your attention to Article 6, Section 1 of the Human Rights Act 1998, which you will find at page 2 of the bundle provided. This states it is illegal for a public authority to act in any way which is not compatible with convention right. This, my Lord, pays no attention to the acts of private organisations, which St Basham's is. I have now, with your Lordship's permission, addressed Section 3 on the same Act. My Lords, this section is very broad in the meaning of public body, but this issue was addressed in the case of Popular Housing and Regeneration Community Association Limited against Donahue in 2001, the England and Wales Court of Appeal. Your Lordship's like a quick overview of the case.
Yeah, a relevant overview.
Relevant. Well, my Lord, the appellant had been declared homeless and the Respondent Housing Association commenced proceedings for repossessing the property under the 1988 Housing Act. The District Judge awarded possession to the Housing Association, which appealed against this to the Court of Appeal. My Lord, the relevance of this case is that there was a quote in here which refers specifically to the handing down of powers from a local authority to a private organisation. May I address that quote?
Yes, please.
Page 3 of the bundle. In this case, the Lord Chief Justice stated that the local authority, in transferring its housing stock to Popular, did not transfer its public duties to Popular. Popular was no more than the means by which it sought to perform its duties. This suggests that when Mr Bunter's parents transferred the duties to educate from the local authority to St Basham's, they did not transfer the obligations to abide by the Human Rights Act with it.
In that case, wasn't popular housing, or wasn't popular housing found to be a public authority?
Yeah, but that was for different reasons, my lord. I just referred to the bit which was relevant to this case, which the Chief Justice stated that was the reason why. No, that was the reason they could have come to the decision instead of why they came to the decision.
Looking to distinguish it from this case,
yeah.
Is it?
Yes, my lord. It would seem apparent that the common practice of private schools is to replace government legislation with their own contracts, which the parents enter into when they pay for their children to attend. My lord, this would be also in the case of when they send to school and the government pays for their child to go to school as well. I would now like to bring your lordship's attention to the case of Cameron and others against Network Rail Instruction Limited in 2006 in England and Wales. Sorry.
That one there, is it?
Yeah.
Is that about item 4 in the bundle?
Yes, page 4, green tab.
Yeah.
Post green tab. Well, in this case, there was a quote from Lord Nicholas, who seemed to approve to an article of Frontiers of Public Law written by Dawn Oliver and published in the Public Law Journal. The judge stated, "It is suggested by the author that a better approach would be to concentrate on the nature of the body itself, its relationship with other bodies, whether public or not, and its position in constitutional arrangements. A number of criteria apart from the nature of their function could be explained when we treat the bodies above as public authorities. By considering these factors, we determine quite clearly that a private school should not be considered a public body, down to the fact that its nature is to make money."
Isn't its nature to provide education?
Surely, my lord, that would be a secondary nature, since who would set it up if not to make money? It is a business at the end of the day. The HM Revenue and Customs treat it as a private business, not as a school. It is treated as a business. So it would seem that in the context of the Human Rights Act, it should also be treated as a business, since other government bodies treat it as such. And also, its constitution is separate from the arrangements of state schools, as it's replaced by a contract between the parent and the school. It'd be for these reasons that we would argue that St Basham's is not a local authority, but a private business, and thus not obligated to follow the Human Rights Act. My lord, I'll now hand over to my learned junior, who will address the issue that the human rights are not actually breached in this case.
Before you do, Aston and Cantlow is the House of Lords decision, so is the higher court, I think, from all of the cases that you've quoted. Can you deal with that case and how you would...
What case is it now?
The Aston and Cantlow case. Which is the House of Lords case, so I'd say the higher court in this. As was just discussed, there were a number of factors to be taken into account in deciding whether or not.
Didn't they deem that it wasn't a public body?
But it's how you get there is the issue, and the factors that are taken into account when deciding. It's whether it's publicly funded. In this case, how do you get around the point that Billy Bunter is assisted and paid by the government to attend the school?
It's an assisted placement scheme. It's to help his parents pay for his school fees, instead of actually funding the school as in state schools.
The next one is taking the place of a government or local authority. Would you say a public school, a private school, independent school is doing that and providing education?
Well, my lord, as I mentioned in the popular case, the powers are handed down. The Lord Chief Justice decided in our case that the powers shouldn't be transferred after they've been handed down.
And finally, providing a public service. So again, do you think providing education is a public service?
Yes, my lord. Obviously, education is a public service, but surely the main purpose of the school is to make money. It is a business, after all. As public service be secondary on the agenda.